Welcome to Kanooni CHARCHA. Today I will discuss the relevant provisions of section 441 of Code of Criminal Procedure. Now this Code of Criminal Procedure 1973, as you know, it is repealed. Now there is a Bharatiya Nagrik Suraksha Sanhita 2023. Its section are corresponding to this section which I have referred 441 of Code of Criminal Procedure Code is 485 of BNS 2023. It is relating to bond of accused and sureties. As you know, when a bail is granted by a court or by a police officer in charge of police station, if offence is bailable. If it is non-bailable, bail can be granted by the magistrate, judge, this magistrate level court or sessions judge, and then by Honorable High Court and by Honorable Supreme Court in many cases. It depends upon the provisions the concerned accused is invoking. Now, as when a bail order is passed by a court, the courts I have already referred, even by the police officer in charge of a police station, as you will find in the relevant provisions of relating to bail, grant of bail by officer in charge of police station in bailable cases and in non-bailable cases by the magistrate, this court of session, court of this Honorable High Court, and sometimes bail is also granted by this Supreme Court of India by invoking its extraordinary jurisdiction or otherwise. Now, when bail order is there, as you know, the accused is directed to furnish personal and bail bond. Mean the accused has to furnish his own bond as well as simultaneously bail this bail bonds of his sureties. You can say bail bond or bond of sureties. It may be a single surety, it may be a two or more sureties. It depends upon the amount or order of the concerned court. Now, I will come to another aspect of the matter. This is sometimes you will find that court on seeing the situation, conditions, and of the accused financial position and otherwise his non-availability to furnish bail bond, he may be ordered to be released on personal bond. Now, this section 441, its corresponding 485 of BNSS is similar situated. This is same verbatim. 441 of Code of Criminal Procedure, I am going to do it. You will find similar provisions in a 485 of BNSS 2023. Bond of accused and sureties. Before any person is released on bail or released on his own bond, I have already verbally this mentioned before you, a bond for such sum of money as the police officer or the court, as the case may be, thinks sufficient shall be executed by such person means accused, who is going to be released from the custody when he is released on bail by one or more sufficient sureties. The conditions and that such person shall attend at the time and place mentioned in the bond and shall continue to so attend until otherwise directed by the police officer or the court, as the case may be. Sometimes some conditions are added in the bail bonds. that he has to attend the investigation and or the trial court after presentation of the charge. So this such type of the condition can be added by an order of the officer in charge of police station in bailable cases, and non-bailable magistrate judge can order the grant of bail subject to certain conditions. But here I want to discuss very important this provision, subsection 4 of section 441, which I have read. Subsection 1. Now I will go directly to what I mean to say, but I'm going to discuss what is the point of discussion today. You will get it from this. I will mention the topic. Topic, you can say grant of bail, I have already said, and by a court, and bond of accused, and what type of order they should be. Now I will read first this. For the purpose of determining whether the surety are fit or sufficient, the court may accept affidavits in proof of the facts contained therein relating to the sufficiency or fitness of the surety, or if it considers necessary, may either hold an inquiry itself or cause an inquiry to be made by a magistrate subordinate to the court as to such sufficiency or fitness. But I have read this section, subsection of 4 of section 441. This is only for the reason because I have today relied upon the relevant this judgment wherein the demand was made by the who were executing. Obviously, the accused was in jail. He was ordered by the Supreme Court of India. By this, I will India. I will make a brief of the fact. Then I will go to the order passed by the, which I am going to delve upon, discuss with you today. The order was to release the accused on furnishing of personnel and bail bonds. But the jail authorities wanted that he must furnish the local surety. Now, word local surety means the cases from the state of Maharashtra. It means the place wherein he is residing or otherwise his resident is, he is supposed to furnish the surety belonging to that place, or otherwise if you go talk in a broader sense, belonging to a state of Maharashtra or the district from which he belongs. This is intention of local surety. Word local mean local of the area of his residence. Now he was unable to furnish the local surety. Then he was not released despite the order of the Supreme Court of India. So again matter came before Supreme Court of India and listed before, and the counsel for the appellant, you may say, accused that he was not released for want of this local sureties. Then I will now go to the judgment, this order, very small order, but it has a this many ramification, you may say, legal ramification on this type of problems, situation you will find common in, generally speaking, the every police officer, officer in charge of police wanted that local, there is now a practice adopted by the law courts and by the police that there must be the local surety who shall furnish the bail bond if bail is granted in favor of an accused. He should furnish the local surety. But it is very difficult if somebody is from not belong to that area or that state. It is very difficult for him to arrange local surety. This is the point, and in this case also, the accused could not arrange the local surety, and he was not released. And again, the accused approached the Supreme Court of India and the Supreme Court of India, in this case, ordered the release of the accused immediately on taking his personal. Now, I have read subsection 4. I will read afterwards, discuss this afterwards. First, I will go to this order. This is a order dated 18th of September 2024, very recent, I think of yesterday. Title of this SLP, Chandra, Thangappan, Achary versus State of Maharashtra. This is a title. The SLP was filed. This is a SLP criminal in nature, means in criminal matters, you may say. Now, this is order dated 18th of September. This is three benches, judges. There were three judges. The three bench consisting of Justice Harishikesh Roy, Justice Sandashu Dhulia, and Justice SBN Vati. These are three judges who made this order. Very small order is there. Now, I will directly go to para 2. The petitioner was convicted and noticed only on the question of sentence on his petition challenging the High Court's order was issued by this court on 4th of March 2024. This is the history of the SLP, the order on record before the Supreme Court. Thereafter, on 3rd of, we are concerned with this bail order. Thereafter, on 3rd of May 2024, when it was pointed out that petitioner has been in custody for nearly 5 years, out of the sentence of 10 years, the accused was convicted and sentenced to 10 years of imprisonment by the trial court, obviously, and it was pointed, made it known to the Honorable Supreme Court of India on 3rd May 2024 that he has already completed 5 years of his sentence which has been imposed upon him. So then bail was granted to the petitioner on terms and conditions to be imposed by the learned trial court. The matter was sent back, and bail was granted. The trial court was given liberty to impose relevant terms and conditions. What happened afterwards? Para 3 you will find. The learned counsel submits that although bail order was passed as far back as 3rd of May 2024, the petition continued to languish in Kolhapur Central Prison. The reason for not getting the benefit of bail order is because accused was unable to furnish local surety. This I have already given you in brief of the facts, that he was unable to furnish a local surety. Then he was not released despite having order of the Supreme Court of India. Now you will see very seriously this non-compliance, you may say, or otherwise whatsoever you will think, the Supreme Court of India has taken a very serious view. Now you will find it in para 4. The justice delivery mechanism cannot be oblivious of the plight of the indigent convicts who were unable to provide local sureties. Now, Supreme Court of India, their lordship have come to the back of this indigent convicts. If they are not able to furnish the surety, they should not allowed to be languish in jail forever. Now, but for their incapacity to meet the bail terms, the applicant continues to languish in jail, notwithstanding the bail order passed in this paper as far as back on 3rd of May 2024. This is observation. Serious view has been taken. They are very serious. Now I will read out para 5 also. This is very important. because 7 years and 1 month, then again he was approached. Earlier, when he has approached the Honorable Supreme Court of India, 5 years period was completed. Now again, and the bail was granted on 3rd of May 2024. Now it has been reported by the bail, this Superintendent of Jail, that he has already completed 7 years and 1 month. Now I will read, you will get a in contest of a 10-year sentence imposed. This is a reference made, their lordship, with regard 10 years imprisonment. This sentence was given to the, imposed to the, upon the accused, Mr. Rtd. He was Miss Rtd. Would refer to the custody certificate dated 9th of November 2023 of the senior jailer of the Kolhapur Central Prison to point out that as on today, this is dated 9th of November. Now order is being passed on 18th of September 2024. I think after around about 10 months, you may say, the petitioner has been in actual custody for 7 years and 1 month. Now you will say the 10 years total imprisonment, 7 years and 1 month was this period 7 has been counted from 9th of November 2023. You add the further period of I think 10 months. Now he is in custody at on the day 18th September, 7 years, around about 1 month less than 8 years. This is, it would be a travesty of justice. This is in para this 6 of the order. If the petitioner unable to secure the benefit of bail order form is inability to furnish local surety, this body is local surety, this will infringe the right granted under Article 21 of the Constitution for the person. Now, the lordships have taken assistance and after this Article 21 of the Constitution of India for the person who continues to detain despite a bail order. This, the word used is travesty of justice. If justice is not done, why making applicability of this Article 21, which talks of right to life. Having considered the circumstances, para 7, here we deem it appropriate to say that petitioner be released on bail on his personal bond without insisting on local surety to ensure the compliance with this court bail order dated 3rd of May 2024. It is ordered accordingly. This is now word local surety. You will not find this section 4(9), which is relevant to the but what is required? I have read subsection 4. If there is a bail order, obviously there is a direction for furnishing of personal bail bond of sufficient amounts in order to secure his presence during investigation if bail is granted in currency of investigation of a case or during trial or at any stage of the further stage, appellate and others. Then what is this subsection 4 required? If accused furnishes surety in compliance to the order of a court or official in charge, the order, the authority who is enforcing the order of the court, they should not insist. If they are insist for surety, local surety, there is no reference in this provision, this section, any of the ingredient, any of the section, the provision that there should be a requisite for furnishing of surety. If there is the officer in charge of police station or a court which has granted bail and enforcing authority, if they are doubtful, they can get verified the credentials, financial credentials of that surety. This is in, you will find it, subsection 4. Otherwise, there is one more thing, that the surety concerned can be asked to furnish affidavit in support of obviously the amount of the bail want. This is a affidavit in support of the facts contained therein relating to sufficiency or fitness of the surety. Means our main concern is the amount of the surety. By he is in a position, he has a financial credentials to pay if the accused fails to attend the court and his bail bonds are forfeited during due course of this trial or at any stage of the proceedings. This is relating to the many, you will find many people, many accused under trial prisoners. Now, in this case, the Supreme Court of India has intervened and the accused gets released. Obviously, I have already mentioned that 7 years and 10 months have been completed, and on the day the bail was granted, it was found that he has completed half of the period of the imprisonment. Many people of such kind who are unable to able to furnish the surety bonds or languishing in jail. So I have come across with this judgment. I thought it proper to have a discussion to lab upon this order of the Supreme Court of India, which is very relevant to the present situation, plight of the under trial prisoners who are unable to furnish surety bonds as ordered by the courts. They are not being released. In this case, I repeat, the Honorable Supreme Court has intervened, and they have also considered the right of life, personal liberty, and life of the under Article 21 of the accused in this case. But I think this is sufficient for today. Thank you very much.